We thank you so much for watching Law School Made Easy at Law School Made Easy 256. And today we want to go to constitutional law. And in here we are going to discuss all the topics to tell you what you need to write. What do the examiners expect from you? We are going to single out a few topics that you have covered in second semester, those ones who are in first year. We thank you so much. My name is Walter and this is Law School Made Easy. But we ask you to subscribe, share and like our videos. Subscribe, share, like our videos. Keep the comments coming. We appreciate them. Constitutional law. This is constitutional law. We have lawyers who have become constitutional lawyers, and many of them you see them. But these are the topics you cover in this semester when regards to constitutional law. Number one is we do the types of the Constitution, what is the Constitution, and then we go to the principles of interpretation. How do we interpret the Constitution? How do we interpret the law? And then we move to Professor Dicey's rule of law, and then from there we go to separations of power, then independence of the judiciary, and then chapter 4, human rights. Colleagues, we want to let you know that some of the things you must expect. For example, when they ask you the types of constitution, you must give the type, you must give, say, written constitution, and then you give where that constitution is being practiced today, where it is, which country is following such a constitution. If you say unwritten constitution, then you go ahead and explain that in this country they use this constitution, of course after giving the meaning and the background. Then we have types of governance. We have types of governance in there still. When you say that democratic governance, then you explain which countries are using the democratic governance. So that is what the examiners expect from you when it comes to types of constitution. But if you see a question that wants types of constitution, the first thing you do is to define what a constitution is. After defining what a constitution is, you go ahead and tell us the supremacy of the constitution under Article 2 of the Constitution, Clause 1 and Clause 2, you explain them. Then after you have explained Clause 1 and Clause 2, you go ahead and now explain the characteristics of the Constitution. And then from that bit, after you have discussed them, you now come down and you begin to answer the question which says types of Constitution. Now, you may say written versus unwritten, but that one doesn't augur well. So what you do, you say written constitution, you explain written constitution, you give a country where it is practiced, and then from there you now say unwritten constitution. They move together, but don't say waile, don't say written constitution, wailo, or whereas unwritten. No, first talk about the one, and then you talk about the other. You follow like that, detail, not detail, and very many others. So when that question comes, but don't forget you always have to conclude. Now let's move to the second topic that we think they may examine you about, and that is ways, interpretation, principles of constitutional interpretation. Colleagues, there are about 11 of them, but when you discuss principles of interpreting the Constitution, the first thing still, define what a Constitution is, and then go into these elements that we follow when interpreting the Constitution. One of them is inherent right. Colleagues, if you talk about inherent rights, then discuss Article 20 of the Constitution, and then tell us what do you mean by inherent rights. Give a case where inherent rights were promoted. For example, in this case, we give Reverend Father Mutikila versus AG of Tanzania. So you explain the concept of that case and then you relate back to the one inherent. If you're saying that another point is interpret the Constitution as a whole. Colleagues, when you're interpreting a Constitution as a whole, now tell us that the Constitution must be interpreted as a whole. So you give scenarios of cases where the Constitution was interpreted as a whole. You must give a case per point you're discussing. For example, you tell us in URA versus Arabo Enterprises what the Justice Lillian Tibatema discussed on the principles of interpreting the Constitution as a whole. You explain. You have Tennis versus Bombay Municipal Council. These are locus classicus cases that you can use to describe a Constitution as a whole. But this is what we need. We need you to write the point. Make sure your point starts a paragraph. And then from there, you now explain. You now explain and say that what do we mean by interpreting a Constitution as a whole, and then you give a case, a locus classicus case, of which I have told you the cases. Then you go to another point, for example, harmonization principle, that where we have contradicting sections or articles of the law, we harmonize. But as you harmonize, fundamental rights are very important. So you give a case where they needed to harmonize, and that is Reverend Father Mutikira versus AG of Tanzania, and very many other points. Sui generis. You explain all those points. So, colleagues, be aware that this number is likely to come, and when it appears, colleagues, answer it the way we have said, the way we have guided on answering it. If you're discussing international treaties, that there are international treaties, if this is what you're discussing, colleagues, tell us that Uganda, for example, in Uganda, we are bound to certain treaties where we have appended our signature as a country. So therefore, you say, when we are interpreting the law, we must put into consideration those treaties where we are bound. If you're discussing, for example, that the law, that where words are ambiguous, and unclear, okay, what do you do? So you give cases. For example, Unity Do versus AG of Botswana. You explain what you mean by where words are ambiguous and unclear, where words are clear and unambiguous. Those are different points. Now you explain what you mean by that, and then you give a locus classicus case, and then you move to the other point. And then don't forget to conclude. Ladies and gentlemen, when you're discussing principles of interpretation, do not forget at all costs to write about sui generis, that the Constitution is in its own class. Colleagues, I advise you, you can bring it number one or number last, but put it number last, that Constitution is sui generis. It is in its own class. Let's go to the other very important topic, and that is rule of law. What do we expect you to discuss under rule of law? Colleagues, the first thing you do, you cite the three elements that Professor Dicey elucidated, that brought out clearly what defines rule of law. Dicey says there must be three things. He talks about a strong government. It doesn't mean a government of people who go to the gym and lift. No, he means a strong government that promotes equality, supremacy of the Constitution, and just government. Justice must prevail. Now, after you have explained all the three of Professor Dicey, then you can, before you even go there, first define what we mean by rule of law. What does the Justice Emeritus, George Kanyamba, in his book, The Constitutional History, how does he define rule of law? He says, this is the rule where the people are the leaders, are led by the same law. This is the principle of George Kanyamba, and very many other definitions. First define, what do you understand by rule of law? How does Professor Dicey define rule of law? How does the Justice Emeritus, Professor Kanyamba, define rule of law? Now, After you have given a very good definition, now move to Professor Dicey's principles of supremacy, equity, and just government. Discuss them vehemently. Now, after you have discussed the principles of Professor Dicey, now go to the elements or principles of the International Coalition of Jurists that was formed in 1959. Now, from there, expand on each one of them. Show how rule of law should be. Independence of the judiciary, it's one of the points there. Explain that if you want to have rule of law, what should be done to the independence of the judiciary? Judges should have security of their job. When they have security, they will be able to administer rule of law whatever they are doing. The tenure must be clear. No judge should be at the job when they are, because of any mistake, they are going to be sent away. By so doing, you are likely not to have justice. So we are saying, colleagues, that you now discuss each element, administration, each element of the international coalition. But colleagues, remember, never leave this number minus giving the negative side, how the rule of law has been violated. They may not ask it, but you must at all costs tell us, however, the rule of law has been violated. Give those very many incidents. The Black Mamba at the High Court, the statements the other day made by the Right Honorable Nabanja about a case in PG, the statements that threatened justice made by the presidents, and very many other incidents where you see people being arrested, being given bail, and rearrested. Yesterday, as we speak, one of the musicians, Fik Gaza, was given a bail and then rearrested immediately. By so doing, you're threatening the rule of law. So now try to pick up all these other examples and then put them there of how this has been violated. There are even cases, the ODC case about the Black Mamba and all those areas. So that is what we expect you to write when it comes to rule of law. Our colleagues, now let's go to separation of powers. When we come to separation of powers, now, separation of powers are what we mean. First, you now go straight to Montesquieu, the French philosopher, on his principles of separation of powers. Colleagues, separation of powers will mean we have three arms of government. We have the legislature, the executive, and the judiciary. So Montesquieu's principle for him is saying that let every arm work on its own. Every arm should be on its own. And then he says that nobody should work in both of the arms. You are here, you should not be the other side. That is Montesquieu. So the first thing you do, you write about the legislature. How is it comprised? What does it do? And then you go to executive. Which article? This is 78, 79, then 99, 98 for executive, 126, 129 for the judiciary. You first talk about each one of them. Then later we develop to what we call checks and balances, which mean that these arms of government are independent but interdependent. They are checked. You now go to the side of checks and balances. You say, however, these, for good sustainability, for good performance, these arms of government check each other. And then you begin to bring how they check each other. Judiciary, 142. Appoint the Chief Justice, but the President approves. Like that, you bring Article 100, a speech of the President. You bring very many articles in there. 100, 101, 127, 104, 107, 86, 85. All those articles are work on separation of power. You now show how each article checks, how each arm of government checks the other arm of government. Colleagues, when you do like that, but don't forget the words of the Justice Emeritus, as he was then, Benjamin Odoki, that the arms of government are like a three cooking stone. They need each other. If you remove one, the other one will fall. The three cooking stone. Don't forget that analogy when you're discussing the separation of power. Colleagues, you conclude on that, and then we move. Then let's go to the second last, and that is independence of the judiciary. There is nothing to write. This is the number for you to do, everyone to do. You only have one role if you're to do this number, and that is you just have to go and read Article 128 from clause 1 to clause 8. When you appreciate those clauses, those are the clauses you're going to write back. You write back all those clauses, and then you bring the case of Marcelo Museni and very many other cases, and you explain the independence of the judiciary. We mean here that when you don't interfere in the work of the judiciary, that is what we call their independence under clause 3. That when you don't interfere in their work, then that means that they have their independence. You go explaining one by one that when you give them their salaries, their money is under clause 5 from the consolidated fund. 1, it actually means that they drive their powers from the people, because it is us who pays the money, what they call the consolidated fund, and then they are paid from it. So they should work in respect of our rights and rules. So when you give them their salary, when they are happy, then it means that they will administer justice. There will be the independence of the judiciary. Then you go explaining all those sections. Their side should not be valid. All those sections, you explain the 8 sections as you attach the Marcelo Museni case and very many other cases. By so doing, colleagues, you will be done. Lastly and finally is the chapter 4, human rights. This is the problem question you're going to do. We pray that it comes, but every year the human rights must appear. Colleagues, you must know articles, the whole of chapter 4. The whole of chapter 4. And you should be able to identify from the problem question which right has been violated. In simple terms, chapter 4, human rights, they are telling you, identify how the rights are being violated. They are telling you they came and picked Yunus from his home. They entered and searched his home. Now, entering and searching his home is privacy. Article 27, right to privacy. No one should come and check your home minus a search warrant. So where they say they had a search warrant, then no, then it is okay for them to search your house. But where they don't have it, then you know that they violated the right to privacy. Then they are telling you they took him to unknown place. Article 23 clearly says that somebody restricted must be taken to a known place, not unknown place, either police station. So they are telling you identify. Then they tell you while in that unencumbered area, they never allowed any of his family, wife, say doctor, lawyer, to access. Then Article 23 should be in your head, 28, that you must give access to my doctor, to medical care, you must give access to my family, you must give access to my lawyer. They even tell you under clause 3 of Article 23 that tell them the case they have done, committed, the offense committed, in the language they understand, and then give them a right to their lawyer. So, in simple terms, they are testing you on did you appreciate the rights? When a right is being violated, can you say they are violating my right of this? For example, they will tell you that he was subjected to forced labor while in prison. Of course, we know under Article 25, no one should be subjected to forced labor. But where we are serving a court sentence, you can be. So a prisoner cannot say that there is my rights has been violated, I'm subject to forced labor. No, you are serving your rights can be taken away from you. Colleagues, as you read these rights, know that the Constitution, in some sections, articles, has given you the right, and in there, they take it away. For example, they are telling you right to life under Article 22. But in the same article, they are telling you when you are serving a court order sentence, that right of life can be taken away from you. So you should know all these articles which have exceptions. Article 22, Article 25, Article 23. They all have exceptions. Then they are telling you they beat him, they tortured him. Article 24. So your role is to discuss and say that by torturing him, they were violating Article 24, which was prohibited. For example, in the case of Simon Chamanywa versus AG, this happened, and then you explain. So colleagues, we wish you the best when you are answering your papers. That's how you go about all these numbers. Thank you so much for watching Law School Made Easy at Law School Made Easy 256. Stay tuned. Until next time, thank you so much.